I'm going to go ahead and get started in the interest of being on time. My name is Camille Nebaker. I am part of the ethics core for Bridge to AI, and this is our December discussion forum where we talk about ethical, legal, and social implications associated with the work we're doing in Bridge to AI. And we have a guest speaker today, Dr. Michelle Mello, is a professor of law at Stanford Law School and professor of health policy in the Department of Health Policy at Stanford University School of Medicine. She conducts empirical research at the intersection of ethics law and health policy. She is the author of more than 260 articles on medical liability, public health law, the public health response to COVID, pharmaceuticals and vaccines, data ethics and privacy, artificial intelligence, research ethics and governance, and other topics. Our discussion forum typically involves about 20 minutes of our guest speaker presenting information about their work, followed by a discussion and Q&A. And so I would invite you to turn on your video if you'd like, or at least when we get to the discussion forum, go ahead and turn on your video so that we can have a discussion together. And with that, I'll turn it over to you, Dr. Mello, and thanks again for joining us.
Great. Well, thanks for having me. I'm going to go ahead and see if I can share my screen here. Hopefully everybody sees one big slide. If that's not the case, let me know. Great. So I'm happy to come and talk about some of the things that have been worrying me lately about AI as it relates to legal liability. As Camille mentioned, I'm a legal scholar primarily, but I'm also interested in how health policy interacts with the law, and specifically how formal kinds of regulation interact with what's going on in the courts. So I want to talk about two sort of emerging developments relating to liability for AI. And, the context that I mostly think about is the delivery of clinical care. But I think that what I'll talk about today also applies to uses of AI in clinical care that are done through research projects. So if you are, for example, testing a new diagnostic algorithm through a research study, the same kind of issues are likely to arise. And similarly, the anti-discrimination rules I'm going to talk about, because they apply to hospitals, are going to apply regardless of the nature of the activity that's being carried out within the hospital. Let me begin with just some disclosures. So I do have some financial relationships with kind of AI adjacent concerns, including consulting companies that help healthcare organizations understand how to manage the AI revolution. I've served as an advisor to Verily in the past, and my spouse works for a company that makes stuff that powers AI. I'll focus on two topics today. I'll talk briefly about a relatively new rule that came out in May of this year relating to algorithmic discrimination, but I'll spend most of my time talking about other kinds of liability, specifically liability that might arise when use of an AI algorithm results in harm to a patient. Again, whether that's in ordinary clinical care or in clinical care that's delivered through a research project. To begin with, I'll just sort of level set by noting that the Affordable Care Act includes a section, commonly referred to as Section 1557, that prohibits covered healthcare organizations, meaning those that take federal funding, from discriminating against people on the basis of legally protected characteristics, as you see here. It's a fairly broad list and includes disability and age. This section applies to virtually all healthcare organizations by dint of their participation in Medicare and Medicaid. And it also would apply to any private insurers that, again, participate in Medicare through, for example, Medicare Advantage plans. Until recently, it was a little bit unclear what the scope of this section was, and in particular, how we might think about its application to various kinds of clinical decision support tools, including, but not limited to, AI-driven clinical decision support tools, or CDS tools, as I'll call them. In May of last year, the Office of Civil Rights clarified that matter. And so I want to explain what's in this final rule and then what it might mean for people who are working with AI. The main thing that this rule did was clarify that indeed Section 1557 applies to the use of CDS tools. That means whether you're looking at a simple risk score based on 5 patient characteristics or a machine learning algorithm based on 1,000 characteristics, if you use that to make clinical decisions or to assist in the making of clinical decisions, the non-discrimination rule is going to apply to your activities. So what exactly does this rule require? There are 2 main takeaways from it. The first is that if you're one of the entities that's covered by this rule, you have to make so-called reasonable efforts to determine whether tools that you are using for CDS use protected traits as inputs. So those protected traits are, again, the things on the previous slide: race, sex, age, disability, etc. So first is inventorying the tools that you use, including AI-driven tools. And then the second is to make reasonable efforts to mitigate any risk of discriminating against those groups based on the protected characteristics if they are used as inputs. So you can notice the use of the word reasonable here. The intention is to be flexible, to let institutions sort of explain what they are and are not doing. But clearly part of that reasonableness is going to be kind of the concept of due diligence, that you've done your homework, you know what's going on within your walls, and you've thought about whether there might be a risk of discriminating on the basis of these protected characteristics. So as soon as this final rule came down, there was a general freaking out, at least in the circles that I travel in, and particularly among physicians who really felt like they were going to be on the pointy end of the stick here in terms of having actions brought against them, and that it essentially was going to shut down any use of these legally protected characteristics in AI algorithms to the detriment of clinical care. So let me just dispel a few of those, what I think are misconceptions. First of all, on its face, this rule does not prohibit the use of these characteristics in algorithms. In fact, if you read the extensive comments at the end of the rule, age, for example, is specifically listed as something that often is and should be in decision support tools. What the rule does say is that if they are going to be in there, it needs to be because putting them in there comports with clinical best practice, which is a pretty reasonable standard. You have to be able to articulate a clinically defensible reason why they are in there. The second misconception, I think, is that this is a rule that's directed at physicians. Now, it's true that this rule is not directed at the parties that you might say are most at risk of creating algorithms that discriminate against people, which are algorithm developers. And that's because those entities are not regulated by the agency that issues this rule. They're just out of reach. Their developers are regulated by other rules, certification programs, but this is for covered entities that participate as healthcare providers. However, the primary targets of this enforcement action are going to be those hospitals and healthcare organizations, not individual physicians. And then finally, what tends to freak people out is that enforcement can involve a really nuclear option, which is that you get terminated from participating in Medicare and Medicaid. The reality is, if you look at the history of how OCR has enforced its rules, this is virtually never pursued as a remedy because nobody wants this. This is a horrible outcome for everybody. Instead, the typical remedy is a corrective action plan, which, while it may be a pain in the butt for the hospital to have to develop and monitor, is certainly not as draconian as termination for Medicare and Medicaid. So there are, I think, reasons to tamp down the degree of freaking out around this rule. At the same time, I think there are elements of this rule that are quite misguided and that pose some real challenges for many healthcare organizations. So let me just sort of wrap up this discussion by noting some of these. The first is that OCR seems to be operating on the assumption that hospitals sort of have lists of all the tools that they are using. Maybe yours does. Mine tries, but it is a moving target, and there are so many different kinds of CDS tools, including old school things, not AI driven, that have been in use forever, that there isn't an inventory in place. So figuring out, first of all, what tools get used is not straightforward. And then to figure out what the inputs to each of those tools are, super not straightforward for AI tools, which again can have tens of thousands of different parameters in them. And hospitals, especially when they're using something that's developed by a third-party developer, don't have ready access to that huge list of inputs a lot of the time. So I think this is actually going to be pretty tricky to obtain. The government is required, whenever it issues a new rule, to generate an estimate of the time involved to comply with that rule. I looked at that, and the agency estimates that the time required to comply with this rule will be 1 hour in the first year and 30 minutes every year thereafter. So if you're that efficient, that's great. I don't think this is even in the ballpark. I don't think that anybody who does bias assessments thinks that this is anywhere in the ballpark of what actual compliance costs will look like. And I think the problem is that OCR seems to contemplate that there isn't going to be a need to do any kind of hospital specific assessment of the risk of discrimination, that this information is going to be readily available from developers. Even if it is, which in my experience, it's kind of hard to pull that out of them sometimes. Even if they've done this kind of bias testing for their algorithm and are willing to share it, there are all kinds of sources of bias that arise from the way algorithms are deployed into a particular setting, into a particular workflow. And it's just not clear how much hospitals are going to be expected to inquire into that kind of thing. So to give a simple example, if we have an algorithm that identifies certain subgroups of patients who could benefit from additional preventive care screening above and beyond like the guideline recommendations, there will be a difference for sure in who responds to invitations to come into the clinic for additional screening. And you can readily guess sort of what direction that would go in, which kinds of groups might be relatively less likely to take up such an offer. So first of all, is that discrimination? And secondly, there's no way to sort of get underneath the hood and really understand that unless you go and talk to the clinics at your hospital. So much, much harder than I think the agency understands. Third, doing bias assessments, like even if you just focus on the algorithm, it's pretty technical. And again, you can rely on what the developer has said, but there are a lot of things specific to your patient population that you would want to be able to examine empirically. Many hospitals are just not resourced to be able to do that. There is also an interesting question, a legal question about whether it is discrimination under this statute if what you're using the algorithm for is something that can be expected to confer a benefit on a legally protected group. So, for example, we had an algorithm recently that we reviewed that is intended to improve detection of a rare cardiac condition that can cause sudden death. It's known to be disproportionately prevalent in the African American population. So if we were to implement it, we would expect differential benefit for African American patients if we can get them into the clinic to screen them properly after we predict that they're at risk. So is that discrimination? Based on recent Supreme Court rulings, it's entirely unclear whether it is or not. And then the last thing I'll say about this rule is that there's a pretty good chance, in my opinion, that this will all sort of go away relatively soon, which is another reason not to freak out too much about some of these problems. Investigating health equity problems, I don't expect will be a priority for the new presidential administration. It's just unclear whether this rule will remain on the books at all, and if it does, whether there will be any resources left in the Office of Civil Rights to enforce it. So it puts folks in a kind of tricky position right now of figuring out whether they should be making efforts to comply with this rule, given that it all may go away in the near future. So with that, let me turn to my second topic today, which is sort of how courts are dealing with liability for patient harms that arise from AI. There are lots of reasons to be worried about this. We have a lot of uncertainty around the risks associated with many AI tools because they don't get as rigorously tested as other kinds of clinical interventions. And we also have a paucity of formal regulation, both of algorithms and of how healthcare organizations use them. And historically, whenever that's been the case, the courts have stepped in to provide a remedy to people who have been injured by this industry that's underregulated. There are also lots of things about AI-related harms that make them, I think, likely to result in lawsuits and settlements. They can propagate over many, many patients. They're sexy. They're the kind of thing that are going to get reported in the newspaper. And when we think about jurors being seated to adjudicate these kinds of claims, that we're going to be seating people who come in with a baseline high level of distrust in healthcare AI. Then you add in the fact that judges have little or no experience dealing with this kind of injury and figuring out how to allocate harm. It all gets to be very uncertain. But again, when we look historically at areas where we've dealt with malpractice liability, when it's proves to be difficult or uncertain as to how to pin liability on organizations, physicians kind of end up being the liability sink. And so there's reason to be concerned. On the other hand, 25 years of research into the medical malpractice system tells us these three sort of facts that most injuries never become claims. Most injuries are not due to negligence. And it's rare, it's sort of relatively rare that the plaintiffs win at trial. So empirically, it's quite hard to prevail on these types of claims. And then when we did research here at Stanford looking at evidence that these claims were beginning to percolate up, there really was very little there. So we looked at over 800 cases of software-related injury that caused physical harm to people. Very few written decisions. It's of course possible that these things just get settled and we don't observe the decision making. But yeah, I think one reason why we don't see more of them is it's actually some real hurdles here for plaintiffs. And just to kind of briefly give the law school like medical malpractice 101 or product liability 101, plaintiffs are going to have problems proving all of the things that they have to prove to recover, especially in product liability. One problem is that some of these claims will surely be preempted, meaning there is no state law cause of action because there's a federal regulatory scheme that says that is how we're doing it. We're not doing it through state law tort claims. We have that for medical devices, which many AI-driven medical devices are. It's just not exactly clear which ones it's going to apply to yet, but it certainly will apply to some. Plaintiffs also have to show that the defendant's conduct fell below the standard of care. And as you see on the slide here, there's a bunch of reasons that this can be particularly hard for AI algorithms. Most of them have to do with the opacity of the algorithm and the court's traditional demand that a plaintiff identify a defect in the product, not just causally connect it to the harm, but say what specifically was wrong about the design of this product that caused the harm. That might be really hard to do in the case of an opaque algorithm. And then there's all kinds of complications that arise from the fact that you can have algorithms that perform well in general that happen not to work well for a particular patient. And, is the physician enough on notice of that fact that for Mrs. Johnson, this algorithm is probably going to underperform, that we would say it was unreasonable for her to have relied on model output. Lots of really difficult questions there as well. And finally, it's not yet clear that AI algorithms are going to be considered a product for purposes of product liability law at all. At common law, it's been very uncommon for courts to hold that product makers can be held liable in product liability for software. So these are some real challenges for plaintiffs. Again, when we went back and looked recently at what was in the written record, there's not a lot of cases. We found about 50 of them. Not all of these involve AI. They involve software of some kind. But they do tend to cluster around certain fact patterns shown here. That plaintiffs will sue the developer of software and the hospital when something goes wrong and there's some allegation that the hospital didn't do its homework to adequately maintain or monitor that system. So here's a couple of examples here of that type of problem. The second fact pattern is that the patient will sue the physician for relying on model output and will also sue the developer for having an algorithm that produced wrong output. And this cardiac screening algorithm example here, I think is a very clear example of where that can go wrong. And then the third fact pattern is a sort of kitchen sink complaint. Everybody gets sued because there is like a physical device that is driven by software that fails. And these are kind of the easiest cases because there is a physical thing. It's definitely a product. It's usually clear kind of what went wrong. But these other two buckets of cases can be harder to sort out. Was there negligence? Is there product liability? And what, if anything, should the physician's liability be? So where all this leads me, I think, is to a few risk management foundation recommendations. Um, One is to sort of acknowledge that although there's potential for a lot of liability here, there are some real hurdles for plaintiffs. And there are particular hurdles in imputing a sort of finding that a physician was unreasonable in relying on model output, again, because it can be hard for a plaintiff to demonstrate that this thing was so defective that the physician should have known better. We also find that judges are not very good at understanding AI and how it's different from other software. And so there's kind of a danger that if these cases get litigated too quickly before that understanding evolves, we might get rules that aren't great and don't really acknowledge the reality of what AI is and how it's formed. But in terms of managing the risk that is there, I think one of my key recommendations is just to acknowledge that different AI tools involve different levels of liability risk for all kinds of reasons, because they do different things. They are deployed on different groups of patients who are more or less fragile. Because the so-called human in the loop has a more or less meaningful chance of catching errors, and because certain kinds of injured patients make better plaintiffs than others. And many, many injured patients have difficulty getting legal representation. So I think it's important, and whenever I hear lawyers talk about AI and sort of caution people and make them worried about liability, I feel the need to remind people that we injure people all the time in human-only healthcare, and there is a real cost to not adopting and not testing tools that can help make progress on some of our most stubborn areas of patient safety, like diagnostic errors, missed and delayed diagnosis. So this idea of like not being overly risk averse and really calibrating your adoption decisions and your monitoring decisions to the actual level of risk posed by the tool, I think is really, really important. My second major observation is that right now, developers seem to be driving the car in terms of executing contracts that establish rights and responsibilities. So they will typically come to a hospital with a boilerplate contract, and that contract will probably say something like, it's the hospital's responsibility to make sure that the tool is used safely, to monitor how it's used. If a patient sues you and us over harm, you have to indemnify us, hospital, for any losses that we incur. There may be little or no provision to ensure that the developer has adequate insurance coverage for its liability, little or no provision to make sure that they're giving the hospital enough information to be able to conduct monitoring of the tool. And there are very, very often disclaimers of liability and of ordinary warranties that all products carry. And again, the developers propose these in the contracts. I don't think a lot of hospitals are savvy enough to know to resist them or feel like they have market power to do so. And just to give one example of the last point of the disclaimer, if you take a look at the terms of use for ChatGPT, this is what you find. It doesn't say that doctors shouldn't over-rely on ChatGPT in making medical decisions. It says you must not use it. You must not use it. So think of all of the generative AI tools that are being implemented today that rely on this model and models like it. There are these disclaimers that are just wildly divorced from the reality of what's happening with generative AI, and yet developers put them out there, nobody resists. And so this is going to set the frame for liability going forward. Another real big concern in terms of risk management, it has to do with automation bias. It's so common to just say, look, there's a human in the loop, there's a human in the loop. We know that physicians will exercise oversight. But with so many of these tools, the whole reason that we're deploying them is that they save time and that people are overloaded. So they often rely, I think, on unrealistic assumptions about how humans are going to behave in the presence of this tool. And so a key risk management recommendation is to help physicians in the few scarce minutes that they have in the day to exercise oversight of AI, to focus that vigilance on the known failure modes in the AI by providing physicians with information about what is most likely to go wrong and for which groups of patients. That's particularly important because the legal standard of care in malpractice cases is starting to evolve. In something called the Restatement of Torts that was issued earlier this year, there's this subtle but important shift in how the reporters describe the standard of care. And in a nutshell, it says that just because other physicians do something in a particular way, that's not going to be a defense if that is sort of like objectively not competent. So if we apply this automation bias, the fact that other humans also do a crappy job of exercising oversight of a model or Gen AI output is not going to be a defense. So it makes it all the more important now to do so. And then finally, I think it's really critical that we users of AI insist that when we're in these licensing arrangements with providers, that we get the information necessary to be responsible monitors of that tool in situ in the individual setting. The last point that I'll end on, I'd be curious for reflections on this point because I'm still trying to work it out for myself, has to do with informed consent. Obviously, of particular importance in the research context and much less flexibility around providing informed consent in that context, obviously. But in the clinical context, there's, I think, a very robust debate right now about what patients ought to be told about use of AI tools in their care. And that matters for liability because they can bring a separate informed consent claim on top of a garden variety medical malpractice claim if they find out later you used it on them and you didn't tell them, and that, you know, would have made a difference to their decision making. So I think some thoughtful policy making at the institutional level about how you make notifications or consents around AI is really critical. So I've already talked longer than I wanted to. I may stop there, and I'm very happy to take questions.
Well, first of all, let me just say that I knew this was going to be spectacular, and you exceeded my expectations, so that's not bad. If people want to ask a question, please raise your hand or put something in the chat. I noticed that, and I see raise your hand, and I'm gonna take the privilege of the chair to ask you a couple questions, actually. And then I'm going to call on Sarah Singer. I do want to notice that Stephen Bedrick was praising you for bringing something that he's been saying for a while. So you go. Two things that I worry about are, first of all, how would you advise a clinician who decides not to follow what the AI says to do? And then the second thing I would ask you is, I think that when AI scribes start going, we're going to find out that a whole lot more is said during the encounter than what is included in the notes. And what should that lead clinicians to do?
So you're talking about like a clinical summarization tool?
Yeah.
Okay. Yeah. Okay. So on the first, the question is, what should a physician do if you feel that the model's recommendation is not right for your patient? I think of this really the same way that I think about departures from clinical practice guidelines recommendations, which is that they're very often eminently defensible, and it's a good idea to document the reasons why you're making the decision at the time. So those reasons might relate to this patient and how she's different or the same as the training data population, for example. So when I talk about empowering physicians to have focused vigilance over models, this is exactly the kind of thing I'm talking about. If you've got a model that was trained at 3 academic medical centers in Boston, and now you've got a patient that looks completely different from that, that would be exactly the kind of thing that a physician would want to know going in to evaluate how confident she should be in this model result. So we want to make sure physicians have that kind of information. But it might also be that physicians depart from model recommendations for all kinds of other reasons. For example, we had one recently where a specialist team was going to reach out to the patient's primary care provider, which is outside our system, and say, hey, we think your patient is at risk for having this thing. Can we call them and have them come in and get screened? And sometimes the PCPs would say things like, look, this patient is already dealing with 3 other problems that are affecting their life a lot right now. They're totally flooded. Like, we can't reach out to them right now. So again, that's very reasonable. But documenting that, and then in that particular case, making a note to like reconsider it in the future, really, really critical. So that's like not a new problem. It's just a problem that's gotten harder because now physicians have more stuff to consider in deciding whether to follow a recommendation. Your second question was about clinical summarization tools and what if they leave out key information about visits. That's something we've been thinking a lot about here. We know it'll happen. And we also know that the reverse thing happens, which is that they produce these bloated notes with all kinds of weird information in there, which can be equally poisonous in terms of like extracting the key bits of information. Obviously, the theoretical solution is that the physician's going to review that draft and remember that something important happened and add that in before the physician accepts the note. But that's exactly the kind of situation that I worry won't happen in reality very much, particularly if physicians now come to feel that they don't have to remember what happened in visits quite as much because the tool will do a reasonable job. I will say I've been kind of impressed with developers' ability to calibrate the length and complexity of these summaries to particular customers. So that seems very interesting to me. There are some that will even say, like down to the physician level, we can prompt it in ways that match the physician's preferences for leaving stuff out versus putting too much in. So that seems like a potential technical solution that might help on the margins.
Great. Sarah.
Thank you. Michelle, it's so great to see you
Hi.
here as part of this group. Thank you for the presentation. So I think, we're working in the context of sort of research that's trying to develop data sets for use for AI research. So my question comes from that perspective, but I think what you were describing is super relevant for us in some of the questions that we've been grappling with. So I'm curious to know what you would say about this. So I'm thinking back to the first half of the presentation around algorithmic discrimination, and you identified early on the protected characteristics. We've had these questions arise about characteristics that may not be on a list, may not be known yet as worthy of being protected, but could very likely be used to identify individuals using existing tools or tools that we expect will be developed sometime soon. And we were sort of thinking about how to grapple with that, both in the context of informed consent and in the context of who you release what data to. And you later described sort of suggestions around calibrating and documenting all of that, but I'm wondering if you have thoughts or recommendations in our context about those kinds of characteristics where we don't yet know what we don't know that is likely to emerge, that sort of stuff. Or I'm assuming that the current rules don't apply to that. So what are
Right, they don't. I mean, if it's not a HIPAA protected characteristic, it's not. It's just not protected. So that's another example of a problem that's not new, but that people have started thinking about more because of the advent of AI means there's just more stuff going on. There's just more data transfers, a bigger data. And you might even say, actually, I might be less concerned about re-identification risk in the age of AI because developers are interested in massive data sets. They're not mucking around with an N of 100, right? Like they've got 100 million people that they're looking at. And so unless there's like a hack, the risk that somebody would be inadvertently re-identified seems more modest. But there's no easy answers. And the broader problem that your question raises is that our whole privacy regime is built on the assumption that if it's not one of these 19 identifying fields, you're never going to be able to re-identify the person, which is just demonstrably false. And some people thought that problem would get fixed, in the next few years. I don't think it's going to be a priority now going forward. So it will continue to be an issue. I guess at the end of the day, particularly for the research context where informed consent drives so much about how data are used, the question is, if you can't be sure that they can't be identified, should people be able to opt out? And as I'm sure you've talked about, there's just a real trade-off there if we believe that opt-outs will be concentrated among groups who are already underrepresented in training data sets and are really desperately needed in order to produce AI that promises equitable benefits. So I think I usually fall on the line of saying that's probably not the direction to go in.
Thank you.
Does anybody else have a question or a comment they want to make?
I do, Ellen, and thank
Yeah.
you, Michelle. That was really fantastic. And I was thinking about if there's a harm, it sounds like it's very difficult for the patient to come out of this hole. And so they're probably going to be the ones that could make a case, but the case is not going to be in their favor for the majority of the time. So I guess and then I think about informed consent. And I've written about the fact that you need to have a level of research literacy and technology literacy and data literacy that most people won't be coming to the door with. And so Ellen and I have talked quite a bit about the need for something other than informed consent to be the gate to entry. And I've been advocating for putting a lot more responsibility on the system. But how would that look? Like, how do we start shifting our paradigm so that the system has accountability? And I think maybe this ruling might be trying to get there, but it doesn't really say who should be responsible. And I know we're all our campuses are trying to put together things, but yeah, I guess I don't think informed consent is the answer.
Yeah, great. So I guess I am sort of thinking about two different kinds of accountability. One is, if a patient is harmed, what's going to happen to them? Who's going to take care of them? And I have long thought that when a patient gets harmed in a way that the institution feels is not up to their standards, whether the claim is defensible in court or not, if it's not up to the institution's standards, they ought to be making a proactive settlement offer and giving an apology. I've worked on that type of approach for a number of years. It has a very strong evidence base in favor of it. And especially when the institution is venturing into new territory that is in this liminal space where it's not research most of the time, like most of the stuff that we're doing with AI is all QI, it's not governed by IRBs. So they don't have any of those upfront protections. And yet it doesn't look like traditional medical malpractice either. It's going to be much harder to recover from. So they're in this weird in-between space. That seems like exactly the kind of space where institutions ought to be stepping up and saying, when we go boldly into this space and we cause harm, we're gonna pay. We will pay them. The other kind of accountability, though, I think has to do with the issues that Sarah was raising about data use. And it remains the case, even though this has also been a long-standing problem of like, what do we do with de-identified patient data? Do we sell it? Do we share it? There are still institutions that don't have secondary data use committees and have really very informal or no policies about how they traffic in de-identified patient data. So the second form of accountability, I think, is having structures within institutions to get out in front of those issues and set policies and set them in a way that feels comfortable to be transparent with patients about, including explaining to patients why we do share de-identified data with third-party companies. Like, how does it redound to the benefit of our patients here and our physicians?
Thank you.
Thank you.
And you have to be somewhere, right, Michelle?
I have a couple more minutes.
Because I'm going to let Jennifer have the final word.
Okay, great.
I think I really appreciate, especially the original earlier on in your talk about the change in government now, and and I think that has a lot to do with strategy or like policies changes by almost every 4 years, maybe now these days. So I'm concerned in terms of, especially a lot of the work that we're doing does include underserved populations and some of the rhetoric that goes back and forth. And now that there's a switch up in January, with how would that look like in terms of policy or even in language of consent? Are we supposed to be thoughtful about this ahead of time? A lot of it is having foresight. As we work a lot with Indigenous populations, and there's a lot of apprehension with anything to do with AI. And it's hard to give, even if we want to do this kind of co-learning with each other, I'm not even sure where to begin on how things might look like in 2 years, and 3 years, and 10 years with AI. And I'm also a fellow Stanford. I'm part of Mike Snyder's lab. So we do with omics and AI all come together with personalized health. So I'd love to have your thoughts on that.
Well, I guess what I've been thinking about a lot is just because there's probably not going to be a lot of formal regulation doesn't mean that there shouldn't still be a lot of governance. So in many ways, the absence of formal rules should inspire us to do more through private organizational policies, through coalitions of healthcare organizations, of which there are many right now, developing standards and playbooks for how we govern AI responsibly. And I think really the problem might simply be that when it's not a requirement, some organizations won't feel as moved to spend time and effort on it. But of course we should, like, regardless of whether it's legally required, we should be responsibly governing AI, and we should be engaging patients. I don't have like great insight into how to do the patient engagement. I'm just embarking on that myself, and I have to say it's been really rewarding so far. We have a project here where we have patients on part of our review process for tools that people want to deploy in patient care at Stanford Hospital. So we have a learning community of patients. I'm doing one today at 4 o'clock, actually, where I say, here's the tool, and we take them through some deliberative focus group discussions about their views. And that's been tremendously enriching. But as you're pointing out, like, the challenge is very often the sort of level of literacy and how we kind of get everybody up to a level where they can have a high level discussion, I think is I haven't figured that out yet.
Well, I just want to thank you so much, Michelle. And I see there's another talk on the 21st. And thank you, Camille, for bailing me out. But I mean, this was really giving us a lot of thought, and it really is just things to think about. But thank you so much.
Thanks for having me. Nice talking with you all. Bye.
Bye.